The meeting is being recorded.
Thank you, Louisa. Hello, everyone. My name is Jose Cisneros. I'm here to adjourn and open the Committee on Special Discipline Case Audit meeting. Today is Thursday, October 28th, and it's a little after 12 noon. Welcome to the meeting. Louisa, if you could please call the roll.
Broughton,
Here.
Chen,
Here.
Cisneros,
Here.
Duran,
Here.
Stalag, Shelby,
Present.
you have a quorum.
Thank you very much. We'll start by opening the meeting up for public comment. Members of the public may speak to any item on today's agenda. Comments will be limited to 3 minutes. If anybody is on Zoom, they can use the raised hand icon to ask to speak in public comment. If someone's on the phone, please use *9. I'm sorry, is it #9 to signal you would like to make public comment. Louisa, maybe you could clarify how they do it on the phone?
We don't have any phone attendees.
Okay.
We have 4 attendees in the attendee pool at the moment, and I do not see any raised hands.
Okay, one more chance, everyone. If anybody would like to make public comment at this time on any item on the agenda, please use your Zoom screen to raise your hand to signal you'd like to make public comment. All right, unless you see anything else, Louisa, seeing none, we will move on to our next item and we will close public comment. Our first 2 items on the agenda today are approval of minutes of our previous meetings. Why don't we take them one at a time? First is approval of the September 27th, 2021 minutes. Is there any discussion, questions on this matter, or do I hear a motion?
So moved.
Second.
Thank you. Motion from Reuben, second from Melanie. Louisa, please take the roll.
Broughton,
Yes.
Chen,
Yes.
Duran,
Yes.
Stalag, Shelby,
Yes.
the motion carries.
Great. Thank you, everyone. Similar item, approval of the October 12th, 2021 minutes. Do I hear any discussion or a motion?
I'll move approval. I'll second.
Motion by Reuben, second by Mark. Louisa, please call for the vote.
Broughton,
Yes.
Chen,
Yes.
Duran,
Yes.
Stalag, Shelby,
Abstain.
I think we need one more vote, Chair, and that would be you too.
Okay, great. I'll vote aye.
The motion carries.
Thank you, Louisa. With that, we'll move on to our next item. Item C, discussion regarding attorney conduct issues and client trust account rules. We'll be taking this one.
This is going to be Randy. We can put up the PowerPoint. So just to give a little bit of context, these were a couple of the other issues, sort of not audit related necessarily, that were raised in the discussion or clarification of the charter of this committee. And so we're kind of tackling all the, I would call them loose ends or remaining issues today, as well as walking through the proposed outline of your committee's report to the board, which will be submitted in November. So go ahead and move forward, Louisa. You can move forward. All right, Randy, I'll let you direct Lisa from here on out. Thank you.
Thank you, Leah. So what we have here are three areas that are regulated by the rules of professional conduct and the State Bar Act that I understand there might be some consideration of initiatives or reforms or just enhancements to assure better compliance with these standards. And so the first one goes to the issue of the timeliness of disbursement of funds to a client by a lawyer in terms of funds held on behalf of the client in the client's trust account. The second one is dealing with lawyer threats to withdraw from representation as a response to a client's disciplinary complaint against the lawyer. And the third one is the general topic of failure to communicate. So we'll take each of those in turn. I'll walk you through what we have in terms of the existing rules and statutes. And then I think the idea was to just entertain a discussion of what more might be needed, if anything. But let's start with the first topic of timeliness of disbursement from the client trust account. We can go to the next slide. So what you have on the screen is a reference to the primary provision that governs this. It is in the rules of professional conduct. It is rule 1.15, which is the client trust accounting rule. Subdivision D7 requires an attorney to promptly distribute, as requested by the client or another person who has entrusted funds, any undisputed funds or property in the possession of the lawyer or law firm that the client or the other person is entitled to receive. And so I think one of the concerns that was expressed is that because the concept of promptly distribute is not subject to a hard line, bright line definition in terms of within 10 days of the check clearing or anything of that sort, that perhaps it gives too much, I'll say, wiggle room to lawyers to delay the distribution of funds. That's possibly a fair criticism, but the promptness standard in this rule has been considered in case law and has been applied to account for all of the relevant surrounding facts and circumstances. So it is a rather contextual standard, the concept of promptly distributing funds. And so I indicate on the slide there that a 30-day interview between the client's demand to the lawyer for their funds and the payment by the lawyer has been held not to be unreasonable. And I will mention, the other bullet on the screen is that the record-keeping standards adopted by the board provide for a quote, monthly reconciliation. And that reconciliation would be the process by which the lawyer would determine, in reviewing the client ledgers and all of the journals, exactly which funds are appropriate to be dispersed because the check is cleared, because all of the other issues of client entitlement have been perfected. At that 30-day interview, as a result of conducting your monthly reconciliation, the lawyer would be on notice that there's no reason for me to hang on to these funds. They are dispersible to the client. And so the fact that the State Bar Court and in the matter of Riley found that a 30-day interview was not unreasonable, was not, in other words, lacking in promptness to distribute to the client, seems to make sense to me. And that can be compared to what the court found in the matter of Berg, where there was a 6-week delay in the disbursement, and the court made a point to identify the fact that the attorney actually dispersed some of those funds as payment to himself or herself during that period, but just didn't get around to dispersing to the client. And so you have the contextual issues in regards to whether or not the disbursement was prompt. And sometimes it's something that can only really be determined on the basis of all of the relevant facts and circumstances. If you did have more of a bright line rule, it could help clients in some instances, but it could also hurt them. And so one of the main issues we see a lot on the ethics hotline are questions from lawyers about clients who would like their funds dispersed, but the lawyer is worried about dispersing those funds because the client's interest perhaps has not been fixed. And so there is a number of things that routinely come up. The funds haven't cleared. The funds have cleared, but there are settlement conditions. This is a plaintiff receiving disbursement of the defendant's settlement proceeds, but conditions haven't been satisfied. And so there was even a case in the matter of Respondent F, where the lawyer disbursed much of what the client was entitled to, but I believe he retained $500 because the client had yet to sign the release and dismissal. And the only way the lawyer felt they could get the client to get back into the office to sign the release dismissal was to hold their funds hostage. And they were candid about that. And the state bar court actually agreed and said, if the client hasn't become fully entitled to the funds, if there were conditions like signing the release dismissal before the client really was entitled to those funds, then the duty to fully disperse promptly is not triggered. There are times when banks can put a hold, depending on the bank's policies on certain funds. And then there's the whole area of disputes. The rule 1.15 is very clear that when there's a dispute concerning trust funds, any disputed portion shall not be dispersed, withdrawn until the dispute is resolved. And the ones we hear about on the lot or the hotline are pretty routine. There's a dispute concerning an outstanding medical lien. There's a dispute concerning a prior attorney's lien. There's a dispute concerning the attorney's disbursement invoice with regards to expert fees or other expenses. And sometimes it's even the attorney's own claim for their portion of their fees, the contingency fee percentage, for example. And so if there's any disputes on any of these typical points, it calls into question the client's entitlement and creates an issue with, again, with regard to the idea that the lawyer is now under a deadline to disperse promptly. And so if you did have a bright line rule, say, 60 days, 45 days, one of the downsides of that, of course, is that lawyers are driven by deadlines. And if the deadline says 60 days or 45 days, but the client's funds have actually cleared and there's no other dispute or anything holding it up, there could be some lawyers who just wait to the time that the deadline is approaching before they actually disperse those funds. And that would not be a bright line rule that would serve the client's interests. On the other hand, it could be beneficial if that bright line promptness deadline is set at a point where most of these issues may have cleared. Again,
Randy, I don't know if you see, Ruben, you had your hand up. I don't know if you meant to take it.
I'm happy to let others talk.
Ruben and then Melanie.
Yeah,
I don't see them, so if someone else could color them, that would be great.
I took my hand down, Randy, but I'll just go ahead and ask the question. And that was, one of the first things you said was the requirement that the funds be dispersible. And it seems to me that if there's a dispute, then those are not dispersible funds, just logically speaking, and maybe the rules say something otherwise. Or if there's a condition precedent, right? The signature on the settlement agreement seems to be a pretty classic example. If the plaintiff hasn't signed a settlement agreement, then the funds really shouldn't be dispersible because those funds are not legally entitled to be dispersed, it seems to me. So that was just it was a comment more than a question, I guess.
Yes. I mean, that is one of the other downsides of a bright line rule. There are some attorneys who, in the face of an impending deadline that the client is waving in their face saying you must disperse these funds within 30 days, might be tempted to disperse because they're more afraid of the client going to the state bar than they are the medical lien holder saying, you never reserved my portion or resolved the dispute as to my portion. And so, again, there are potential issues with a bright line standard.
I could just add also, it is quite common, especially in personal injury cases, where a bright line rule is just not realistic. Oftentimes, there are medical liens that the attorney is trying to negotiate because it's not unheard of that medical bills can actually eat up the entirety of the client's settlement funds. And so it can take some time for an attorney to try and negotiate those down so that a client could actually receive some funds. Also, there are statutory liens that an attorney might be required to pay out, and sometimes those can take a significant amount of time to settle as well. But I do think that the language of the rule is very challenging. This idea of promptness is really then fact specific. And, as Randy mentioned, there is case law around it, so it helps shape what prompt looks like. But even in the cases that he's given examples of, I mean, they are still fact specific. One thing that I was thinking about, and I literally just thought of this morning, so I don't know if it would be realistic or not, but it's sort of splitting the baby a little bit. And that is, if there was essentially a rebuttable presumption of a bright line rule. So for example, if the rule was that the funds were to be dispersed within 60 days, so that for our purposes, it's very clear at the 60-day date, and even for the client, that if the funds haven't been dispersed, there's a rebuttable presumption that there's a violation and that there has been an improper holding. But it's rebuttable. And therefore, then the onus would be on the respondent attorney to say, this is why the funds haven't been paid out. And I think for our purposes, that might be actually much more manageable to try and enforce.
Thank you for the input, Melanie. Let's do Melanie Shelby and then Mark Broughton. Go ahead, Melanie.
Hi, Randy. Can you place this into context for me in terms of placing the examples into context in terms of what percentage that it represents as it relates to prompt disbursement? Are we talking about something significant? Are we talking about something in the single digits? I'm just trying to put it into context.
I can only sort of speculate based on anecdotal information about the frequency of inquiries with the ethics hotline. I would say concerns about dispersing funds are really centered around, as indicated previously, that the funds are funds to which the client may not be entitled to in terms of their interest becoming fixed, more so than questions about situations where the funds entitlement is not endowed, there are no disputes pending, they're not negotiating any medical liens for the benefit of the client. I think in those situations, the attorney knows that they should be dispersing those funds, but maybe it's more in terms of how often does this come up as a disciplinary violation. I don't know if Melanie has any thoughts on how often the failure to disperse promptly is a complaint.
I mean, I couldn't say for certain. I will tell you that it wouldn't be unusual for us to get a complaint like this. Oftentimes, it's a matter of communication issues too. Just the fact that the clients don't understand why they aren't receiving their funds when there might be a very legitimate reason for it, some of the reasons which we talked about already. It also could be that the attorney doesn't have the funds, that the attorney has misappropriated the funds. That could certainly be a reason why somebody hasn't paid. But, because we're oftentimes not going to get a complaint from a client that says the attorney has stolen my funds. It's usually, I can't get my funds, or I can't get a hold of my attorney. I can't get a response from my attorney. So it wouldn't necessarily be uncommon to hear this.
So maybe I should have asked the question a different way, because I appreciate the very lawyerly response that you all provided. But as a non-attorney, I'm just trying to put it into context. Is this a major issue? Is it, where does this register in terms of significant issues? Is this significant as it relates to prompt disbursement, or is it not significant? I'm just trying to put my arms around that. And I'm sorry, Melanie, maybe the numerical representation wasn't a good question, but I'm just trying to see where is this a hot issue? Is it a medium issue, or is it a smaller issue? That's what I'm trying to understand. Thank you.
So my response would be, and this is just sort of a feeling response more than anything, is that I would put it middle of the road issue. It's definitely enough to be talking about and considering whether there is some solution to it.
Thank you.
Thank you, Melanie Shelby. Mark Broughton?
Sorry, thanks. I do like Melanie's notion of her suggestions, but a couple of things that I mentioned, you know, in the number of the people that I talk to that have the various accounts that are doing these things, the issue of paying of liens, in particular Medi-Cal liens and those type of things, came up because it can take as long as 6 months to negotiate that. I don't know how you deal with that, except perhaps to say, I think it's important to try and put a bright line on it. I mean, I liked Melanie's idea. And the reason is that the attorneys can sit on this stuff indefinitely. And I think that's one of the problems that came, that we're looking at, that raised this issue. So for example, could you say something along the lines of 60 days upon payment of the last lien, or that the attorney cannot pay themselves until that last lien has been paid. I think it needs to be 60 days from something, and not just receiving the check, but whatever that time frame is. And the firms that I spoke to thought that that would be a good idea as well. So I like that idea. I also think I don't like the way the rule is set up. It says as requested by the client. You know, the client may not know. I think it should be what I would call self-executing. In other words, that check comes in, and like Melanie suggested, it's 60 days from that point. And I'm just using that number because we've been talking about it. It's a rebuttable presumption. If there are liens that need to be paid and so forth, then those can be taken care of. But I don't like the notion that the client, who may not even know that there's been a check that's been received for them, they may not even know. So I don't like the fact that the client has to request it first. I think the attorney needs to be the responsible party.
Thank you, Mark Broughton. Does anybody else have any comments? Richard, I see your hand up. Go ahead.
Yeah, just as a point of information, I did get some data from Ron B. at the Office of Research and Institutional Accountability. And the data from March of 2019 through December of 2020, so 15 months, the complaint called, failure to timely refund undisputed funds, which was a violation of 1.16E2, which sounds like what we're talking about here. I'm not a lawyer either. Anyway, there were 1,666 of those complaints, which is the #1 complaint out of the 10,000 fees and funds complaints received during that time. So just as a matter of fact, if that helps the committee.
Sounds significant to me.
Yeah, Randy, what is there a rationale? I'm sure there is, but for the as requested by the client piece in the rule?
And so I think the presence of that language is because that portion of the rule really shouldn't be read in isolation. The trust accounting rule has specific requirements that the lawyer must notify the client upon the receipt of any funds for the client. And so if the lawyer is required to inform the client that the settlement proceeds have come in, then that really does empower the client to say, well, please pay me my money. And so I think the concept of the rule is that if the lawyer is abiding by all aspects of the responsibility, they have received the funds on behalf of the client, they have provided notice to the client of that receipt, now they're going to resolve the entitlement, make sure the client's interest is fixed, and will properly disperse it. I think that's the way the rule was intended to work.
Okay.
Okay. Any other comments?
But here's what I want to ask. Does this committee want to move forward with exploration of establishment of a rebuttable presumption bright line rule?
I would say yes.
I would certainly say yes. And I would say that I feel the comments I've heard indicate, particularly Mark Broughton, your comments, thank you, and yours, Melanie Shelby, I think we're seeing an interest in it. I think we're trying to clarify what's the right way to do it. I guess a couple thoughts occur to me, Randy and Melanie. You bring up, conditions, liens still being negotiated, all that. I would ask if the staff could, if you all could possibly find a way to word it that says, the bright line countdown starts when everything else is finished. However you would say that in legalese, right? All the liens have been negotiated. All the bank matters have been, timed out. All this, all that, whatever you said are possible, gotchas that don't make it appropriate to disperse the funds yet. Find a way or put just a broad language in there that kind of tries to capture them all, and people, attorneys and clients can discuss, and the state bar can later decide, which falls within that thing. But I just as a non-attorney, rebuttable presumption doesn't tell me much about, as a non-attorney, what kind of protection I'm getting and what a rebuttable presumption is. So I think a little bit more plain language that just says, when all matters have been decided, all issues, anything else left to determine if this, if these are the final ready to go funds or not, that's when the countdown starts. And I definitely agree that it should not, I don't know what the intention of was, that the client, anything gives them the impression that it doesn't have to be sent until the client requests it, or there's some sort of incumbency on the client to have to ask to receive their funds. I think that should absolutely be eliminated. The attorneys are in charge here. The attorneys know what's going on. The attorneys have the control of the funds. It's their responsibility to do with it what should be done. And at some point, what should be done with the free and clear funds that belong to the client is they should be given to the client. And within a prompt amount of time, and I think there should be a bright line that says what that limit of that promptness is. Anyway, I see a couple of more hands, Mark Broughton, followed by George.
Yes.
Mark, go ahead.
Very quickly, if we're going to do a bright line, I would say, and pretty much this deals with personal injury settlement money, right? You receive a check from the insurance company to settle a case. I think the bright line for the rebuttal presumption idea starts upon receipt of that money. Most of the time, the liens and so forth would be negotiated or discussed ahead of time. They will take some that would occur afterwards. But I don't think the 60 days, if you will, we're just using that, would start after the negotiation. It's you want to move that thing along. So I would say upon receipt. The other thing I would point out is that not everything is a PI settlement that's held in IOLTA accounts. You can have clients that pay you money, pay the attorney money for expenses and experts and things like that. So it would be upon closing of the case, or whenever that the obligation on those funds is no longer necessary. That would be the point at which the 60 days, if you will, the bright line rule would start to run.
Thank you. George?
So I had a question for Randy, but as I read the rule, Randy, does this promptly distribute, as I read it, it doesn't kick in until the funds or property are undisputed? And it's undisputed that the client has a entitlement to receive it. Is that right?
Yeah.
So that would be after resolution of any lien.
Yes, so the case law refers to it as fixed and earned, and where there is no outstanding dispute. And so any obligation to promptly distribute is predicated on an initial determination that the client's entitlement was fixed and that there was no dispute. And so that means the lien issues, the medical liens, the prior attorney liens, the statutory liens, any other disputes or conditions will have cleared before that point is reached. I think those are the magic words: fixed and earned and no dispute.
Right. So changing to a bright line after receipt would be a significant change from what this is.
Well, I think I was understanding Mark's recommendation to be start the clock ticking, but the payout shouldn't happen unless all of those things actually happen. But you're trying to light a fire under the feet of the lawyer to make it happen. Am I understanding that right, Mark?
Yeah, I think so. If you wait until the end, the attorney can be doing all kinds of things with that money before they actually have an obligation to distribute it. The other thing that occurs to me is, the bar is never going to know about any of this as long as the attorney doesn't have to report it, unless the client makes a complaint about it. I'm not so sure, as I sit here thinking about it, I've become kind of prosecutorial in this discussion, as I think to myself, is that when the attorney receives the funds, should the bar be notified that you have received settlement funds on behalf of a client that now starts the clock ticking with the bar? I don't know.
Great question, Mark. Any other thoughts?
I just wanted to go back to George's comment, because I think you're right, George. I think it is a big change.
It is.
And I don't know if it seems like a positive change. It's one that will be really interesting to put out for public comment, see what we get back.
I mean, the rules shouldn't be changed to require an attorney to disperse, contrary to the long-established standard of fixed and earn and not disputed. I think the change that we're talking about is to try to create a time frame that gives urgency to the matter appropriately for the lawyer to pay attention to it. And let me also mention that the concept of a rebuttal presumption has been used in regard to the lawyer advertising rules. And so the lawyer advertising rules authorize the board to adopt presumptions concerning the burden of proof to find misleading, false, or improper solicitation based on a presumption. And so one of the former presumptions was that if the lawyer provided guarantees or warranties concerning the outcome of a case in an advertisement, then that was presumed to be a violation, presumed to be deceptive or misleading, and prosecution would have met the burden to go forward just based on the fact that the advertisement contained that. And it would be up to the respondent to show why a guarantee in an advertisement was not false, deceptive, or misleading. With the last revision to the rules came out for 2018, all of the presumptions were migrated out of the presumption category, and they were made either hard and fixed black letter requirements or addressed in the comments. So we really don't have any of those presumptions activated right now, but the concept of a presumption affecting the burden of proof in a disciplinary proceeding has precedent in the advertising rules.
So Mark, we have more. I think we need to move on, but I see Jose.
Mark Roden, is your hand up again? Oh, you took it down.
I just undid it. I would say though, just very, very quickly, that what started this committee and the whole thing was the cyclone bomb of trust account mismanagement. And I think we have to take a look at all of these rules and ways to try and avoid any of these things happening in the future. And I think that's why I'm a little aggravated about the whole thing.
Thanks. Me too. I think, Leah, you've got an answer that the committee is still interested in making some improvements here. Bright line. Maybe do you think, Leah, you and staff could go back and give us some sample language that might be able to incorporate some of the things we've discussed here, and we can refine it at our next meeting?
Yeah, I think we can try to do that. I also think when we get to the section of today's agenda where we talk about the report, we can talk about the fact that I do think we're going to need, after your report goes to the full board, then we need to go through the process of actually rule drafting.
Sure.
Okay. Yeah.
And on that score, I think COPRAC might be your best place for exploring this. Nice.
That's good to know. Ruben, you have your hand up?
Yeah, I actually second Richard's comment about COPRAC. That's I was thinking that as well. On the Rule 115E, the monthly reconciliation, that's, I'm assuming, a self-executing rule or a lawyer executing rule. We don't require any certification that lawyers are in compliance with that, or do we? I mean, how do we enforce that? How do we know it's being complied with?
It is part of the board adopted record keeping standards, and lawyers are expected to comply there. To my knowledge, there's no monitoring or reporting of the carrying out of a monthly reconciliation.
But Ruben, that I think the aspect of the audit program, there is an aspect of the audit program, calling it that loosely, that you all sort of settled on at our last meeting that would require an affirmative indication of compliance with all of the elements of 1.15, an annual certification of compliance. So that is part of what will be in your final recommendations to the board.
Okay, I think that makes a lot of sense. Thank you. I'll lower my hand.
Let's move to the next one, Randy.
Yep.
So the other concern that was raised was this issue of lawyers threatening to withdraw from a client's representation in response to a client complaint. And we do have something that's really robust in the State Bar Act that addresses this. Business and Professions Code Section 6090.5, which was recently revised, operative January 1 of this year, basically imposes a very broadly stated prohibition against any sort of agreement or even attempting to agree with the client that either misconduct won't be reported, the complaint that's already been lodged will be withdrawn, or that the lawyer will, or excuse me, the client will not cooperate in the investigation of the lawyer by the State Bar, or that the record of anything that would be relevant to discipline of that lawyer would be sealed from review by the State Bar. And so that is a statute that's been around for a long time. In earlier iterations, it was much narrower. It was only for plaintiff clients and in regard to a settlement of say a malpractice suit. And so the early versions of 6090.5, there are some discipline cases that even, they could not find culpability because of the limited terms of the rule. But it really is now one of the broadest prohibitions on this type of conduct. We also have in the rules of professional conduct, Rule of Professional Conduct 5.6, restrictions on right of a lawyer's practice. Paragraph B provides that a lawyer shall not participate in offering or making an agreement which precludes the reporting of a violation of these rules. And so we have both the rule, although the lawyer participation offering or making might be viewed as a limitation that you don't have in the statutory section, because the statutory section is just any sort of agreement whatsoever. And in terms of the underlying policy, of course, the concern was that the lawyers would not be able to evade discipline by entering into these types of agreements. But there was also concern that clients would not seek to profit from the ability to protect the lawyer from discipline. And so the current statutory provision, again, it's very broad. It doesn't matter if it's coming from the client, doesn't have to come from the lawyer. If there's any agreement or attempted agreement whatsoever to shut off a complaint, it constitutes a violation for the lawyer, or if you're negotiating with the lawyer who's representing that lawyer, it's a violation as well. So it's very, very broad and should encompass most of these situations. The other tension, and it's the second bullet on the screen, is that the causes for permissive withdrawal under Rule 1.16 include situations where the client by other conduct renders it unreasonably difficult for the lawyer. And there have been cases where it's been acknowledged that if a client is threatening or has brought a complaint against their lawyer, that could result in a breakdown of the lawyer-client relationship, the failure of the trust and confidence relationship that the lawyer feels is needed in order to continue the representation. So it is recognized as a valid cause for withdrawal that if there is that breakdown in the attorney-client relationship and the lawyer doesn't feel like the client won't answer my calls, I can't respond to discovery, There's no way I can continue to represent this client because they now see me as the enemy, that seeking to withdraw is appropriate. And under Rule 1.16, the third bullet, there are certain protections. No lawyer should be withdrawing from a client without taking reasonable steps to avoid prejudice to the client. And if you are before a tribunal, the rule states clearly that you cannot withdraw from representation without first obtaining the permission of the tribunal. So all of those things are holding in check the lawyer who would try to jump ship at any point where they feel that they're unhappy because the client has lodged a complaint. Having said all that, it is not the case that there is a rule that expressly says a lawyer shall not threaten to withdraw as a response to a complaint. And so I don't want to mislead you into thinking that because we have these provisions 6090.5 or 5.6b that prevents the lawyer from talking about it or entering an agreement to do so, that the precise thing that has been identified as the problem, threatening to withdraw, is absolutely covered in every instance.
Melanie, I'm wondering if you would weigh in here, because when we've discussed this, I had understood that it was very difficult for OCTC to kind of prosecute this particular issue. So even though it looks like we have this fairly robust statutory scheme, in practice, is this difficult to navigate?
Well, it definitely has been historically, which is why we sought the statutory change. So you see that this was just operative January 1st, 2021. And because we had lost counts on this particular issue before. So I'm hopeful that at least for the misconduct that the statute covers, that we will be in a better position. But sort of like what Randy just said, I mean, there isn't a statute that specifically says that an attorney cannot withdraw from a case if someone files a complaint against them. The issue comes in is it has to, they have to avoid, reasonably foreseeable, prejudice to the client. So that's going to be a fact-specific inquiry.
And
Any discussion?
We do have a rule that actually governs threats, but not the same types of threats. Rule 3.10 prohibits the lawyer from threatening to present criminal, administrative, or disciplinary charges to obtain an advantage in a civil dispute. And so, for example, threatening to have the opposing client deported as a way of making their civil claim go away is prohibited. But we do see in some of the cases in the ethics opinions, the difficulty with implicit threats or threats that are inferred from circumstances. So the threatening criminal, administrative, or disciplinary charges to gain an advantage in a civil dispute, you hardly ever get the case where you have the smoking gun email that says, if you don't do X, I will do Y. You're always going to end up with, well, based on the way things unfolded, it certainly feels like there was an implied threat, or one threat could be credibly inferred from what was said. And so rules that seek to get at conduct described as threats, I think have their own problems.
Thank you. Any thoughts, questions? Leah, were you guys looking for guidance?
Yeah, it doesn't seem like this is one where the committee wants to explore further sort of rule changes at this time. I hadn't really focused, Melanie, on the fact, or Randy, that this statutory provision just went into effect this year. So it sounds like it would be appropriate for us to see how it plays out over time, if it does kind of address some of the issues that we've seen, and if not, revisit it at some point in the future.
Okay.
And along those lines, I think one thing that might be considered is that I can talk to Andrew Tuff and our COPRAC folks and say that this has just, been revised effective January 1, it might be time for a fresh ethics opinion that really conveys to the licensees that they are under the broadest possible iteration of this prohibition now, and to include some hypotheticals that show that some of those older cases that were under the former versions of this rule are no longer sort of limiting what this prohibition is intended to get at. So maybe a COPRAC opinion on the new version of the statute would be a timely thing to do.
Makes sense.
Yep.
Want to move on? I think we have one more.
So the last one is, and this is one I'm going to sort of ask for some help in telling me what the actual concern was, but it's the longstanding issue of failure to communicate. And we have a rule and we have a statute that are very clear that lawyers are obliged to keep clients reasonably informed of quote unquote significant developments, and they have to promptly respond when their client seeks information, and when you need to provide a copy of something, then you have an obligation to do that as well. And so failure to communicate, I think by urban legend, is the #1 complaint to the discipline system. I don't know if that's true, but the rules are fairly clear. Anything that is a significant development, such as receipt of trust funds, such as the assertion of a claim by another person that creates a dispute as to your entitlement of trust funds, the fact that the med lien holder won't compromise their lien, all these developments in the case that might pertain specifically to why the money isn't being dispersed, I think qualifies significant developments that the lawyer would have to volunteer to communicate to the client, or that the client could seek information about, and the lawyer would be under the gun to provide that information. And so the status quo with the duty to communicate, again, I don't know what you could say more to improve or expand upon the existing standard that requires, in all cases, that the client be reasonably informed about any significant development.
Thank you. Mark Broughton?
Well, I do think you could perhaps more clearly define significant developments. Again, we're talking about somebody who is taking money from a trust account, or who is commingling funds or something along those lines, is not likely to automatically tell the client that he or she is doing that. And they may look at significant developments and say, gee whiz, I don't have the obligation to tell them that I received this settlement until the funds are ready to be dispersed. So I think maybe, significant developments, including but not limited to, you could go that route, or have some opinion that says the receipt of settlement funds on behalf of the client, or something along those lines that more clearly identify what significant developments are.
I was thinking something similar. I was going to ask Melanie, not just that, but a lawyer must promptly comply with reasonable requests for information on copies. Is the promptly a challenge? Would that benefit from more specificity? Reasonably informed. I'm not sure what reasonably informed means either.
Yeah. I can't say that we really struggle with these. There is some squishy language that you've pointed out, but for the most part, it doesn't stand out to me that we have challenges for this. For example, when I see a lawyer must promptly comply with reasonable requests, because the other thing, the flip side from the attorney's perspective is, what's a reasonable request? If you have a client and it happens, that they're calling you, 5 times a day, is it reasonable to expect the attorney to respond to every single one of those calls? So, I think we have enough to work with in the rules and in the body of law that accompanies them, to put some parameters around these sort of more vague terms. So I haven't really had the same experience as with, for example, the other rule that uses the term promptly.
Anyone else?
Let me mention that a long time ago, when one of the earlier versions of the Rules Revision Commission was beginning its project to revise the rules cover to cover, the commission sought input from ethics hotline staff on what areas in the rules could use clarification. And one of those topics was, what does significant developments mean in regards to the attorney's duty to communicate? Because the ethics hotline staff would receive that kind of question. And ultimately, what did go into the rules, that's not very satisfying, I'm afraid, but comment 1 to Rule 1.4 provides that a lawyer will not be subject to discipline under paragraph A3, that's to keep the client reasonably informed of significant developments, will not be subject to discipline for failing to communicate insignificant or irrelevant information. Whether a particular development is significant will generally depend on the surrounding facts and circumstances. So again, you get back to this contextual nature of the standard. But I did hear back from the hotline staff that using the contradistinction of insignificant or irrelevant information was helpful for the issue that Melanie described, which is the tension with the client who is calling, 5 times a day, or the incarcerated client who's demanding multiple copies of transcripts, for example. Those are things where, in terms of the spectrum, you could say that it's not reasonable or wouldn't be a violation of the significant developments aspect of the rule.
Yeah, but Randy, we're talking about something specific here. We're talking about client trust accounts and information and activities that relate to that. Could you have a comment that says reasonable developments includes, but is not limited to, receipt of funds in a client trust account or something along those lines, so that you add
Sure.
that information specifically into the rule somehow?
The thing is, I go by the maxim of law where the specific governs over the general, and because we have in 1.15, paragraph D1, a lawyer shall promptly notify a client or other person of the receipt of funds, securities, or other property, which the lawyer knows or reasonably should know the client or other person has an interest. And so that's been the longstanding provision for going after a lawyer who is not in good communication with the client about funds being received into the trust account. We have black letter law under 115 for requiring that type of communication with the client, but it doesn't mean we couldn't add a cross-reference under the communication rule to say, it's a significant development consistent with 1.15 to talk to your client when the funds come in.
Got it.
I like that.
Yeah. George.
Sorry, I didn't get to my lower hand enough. That's what I was going to suggest, a note like note 3 that makes clear that with respect to trust accounts, the more specific requirements there apply, and that this rule doesn't override them.
It certainly shouldn't limit that other standard.
Right.
Hey.
Good.
All right, so I think that wraps up the sort of attorney conduct or rules portion of our discussion. Next up, we're going to hear about work being done to increase training for both OCTC staff and 2201 counsel on CTA issues. Sorry, Randy. I think this is actually the last slide. I think these were some of your ideas for things we could do.
Yeah, and this was if the group was not ready to consider exploring particular actual changes to the standards, that there's always these tools that we could go to. The education the outreach, we did even talk about an ethics opinion on 6090.5. So these are things that are always options.
Okay,
All right, so now we will turn to the training portion of the agenda. I don't think this is going to be too long of a discussion, but I don't know, Jose, if you want to take a break or
no,
not.
let's go ahead.
Okay, so I'll turn this
Lee,
over.
I'm going to drop off now. Thank you.
Thank you, Randy.
Randy.
Bye-bye.
I don't know if this is going to be Melanie or George.
I was planning to do it, but okay. So, one thing that I want to point out for the office is that around 2017-ish, the office formed a formal training and calibration team. And their primary responsibility is to train new employees coming in and then to either put on or organize training throughout the year. And also to organize outside training opportunities for people. And so prior to that, training was often done sort of on an ad hoc basis. Whenever new people came in, it was sort of catch as catch can, who's available to give training. A lot of times materials were quite outdated. And there was no formal centralized place to manage training throughout the year. So in the last handful of years, we've already made great improvements. But with regard to client trust accounts specifically, in the regular training that the new staff get that come in, and this is primarily attorneys and investigator staff, they are all trained on the basics of client trust accounts and investigating and prosecuting client trust account violations. I think where we have not been as good and where we're refocusing and have in the last several months is sort of ongoing refresher training on some of these more substantive issues. So for example, I'm just going to take you through some of what we've been doing. And I want to say we started in around June, maybe July of this year. And we have done 3 modules so far directed at client trust account misconduct and investigating violations and prosecution. We have at least one more to do on the charging and prosecution of client trust account violations. Sort of the way it's gone, though, are a lot of folks have a lot of questions and a lot of good stuff is coming up. So we have some room if we want to expand these modules beyond the 4, we will be doing that. So, as I mentioned, new staff get the trust account training, and we've had refresher training over the years, but this is a more organized and focused group that we've been doing. You can go ahead and move on to the next slide, please. So like I said, we've had 3 sessions so far and 5.5 hours of trust account training so far. It has been put on by some of our more senior attorneys and our more senior investigator staff. We've been doing them by Zoom. It's mandatory for all attorneys and investigators. And we also often have, for example, paralegals who participate. And when I say attorneys, I mean all of our line attorneys as well as our supervisor and management staff have participated. So can you go ahead and move on to the next? So in session 1, we just started with the basics of client trust account rules and elements that we're looking at for proving particular violations, and just talking about subpoenaing client trust accounts, when we subpoena, how we subpoena, what we subpoena, et cetera, what it is that we're looking for when we subpoena. In the second session, we went over sort of more in-depth investigation into records and actually how we formulate our inquiries and interviews of respondents. The importance of getting ledgers and journals. So it sort of goes back to the reconciliations that we were talking about earlier, that the rules require. Attorneys are also required to keep trust account and client ledgers and journals, which help us to to actually trace funds, what funds belong to whom. You might imagine that folks who are misappropriating money are not the best at keeping records either. So oftentimes that's a red flag for us. Ruben, did you have a question?
I do, yeah. On that point, do we have the ability to subpoena records from banks to verify the attorney's ledger and journal versus the actual funds in the bank accounts?
Well, we have the power to subpoena the actual bank records. Of course, then what we need from the attorney is, if they exist, their individual ledgers and journals that they're keeping.
Okay.
Otherwise, it can be challenging to figure out whose funds are whose.
Thanks.
We also do have the ability to subpoena non-client trust account records, for example, operating accounts. We don't have the same authority in that there's essentially by having a client trust account, the attorney has given permission for us to subpoena the client trust account records in the context of investigation. That's not true for just a regular operating account. So in order to actually subpoena an operating account, we have to give them notice in advance so they have an opportunity to litigate over whether or not we're entitled to those records. But in any event, session 3 focused on misappropriation and commingling. And looking for the red flags when we're actually looking in the trust account records to figure out what it is that we're actually looking for, and what we should be concerned about when we see certain things in there. And then the session 4, which has not yet been held but should be in November, is actually drafting the charges and actually prosecuting these cases. Okay, can you go ahead and move on to the next one? Oh, that was it. So that's what I have. I can take any questions. And then I think Robert is going to talk about the OEX program.
No question, Melanie, but just thank you.
Sure.
Just thank you for that piece of the presentation. I thought it was very clear and concise, and I think it's good evidence of some positive, meaningful steps there in terms of solid training.
Good. And I also just wanted to add that the client trust account training for entire staff will be held annually. We won't be doing 6 hours of it annually, but we will be doing it regularly for all staff, and it will be required.
Great. Thank you.
Okay, so if the committee does not want to make any sort of recommendations in this area, we can move on. And Robert will talk about the 2201.
Okay, great. Good afternoon. Elisa, if you can put up the first slide. Okay, or the slide on the training. So when an STTC is appointed, they are initially provided with a comprehensive OCTC created training binder, which includes subject matter outlines and examples of pleadings and other resources. There is also a case-specific on-the-job training, which is part of the STTC administrator's job duties, which is to provide supervision and training of the STTCs. So if there's a case or a matter that needs further guidance regarding procedure or subject matter expertise, the STTC can consult with the administrator. It's interesting to note that prior to 2016, the 2201 program didn't have an administrator or any lead role providing that type of guidance and oversight. So we do have that training resource in place now for STTCs. And on the screen, you'll see a list of the trainings that are available to them. You'll see that I think there's 3 of them that cover client trust accounts and as well as other subject matter areas. These are pre-recorded trainings that are available to the STTCs on demand, and they cover a variety of areas. They receive MCLE credit for these trainings, so they do have an incentive to take these trainings for that reason. The committee should know that we currently do not require the STTCs to attend or complete those trainings. And one of the things that we're looking at is considering adding it to their contracts for the next year as a requirement that they complete certain hours of these trainings, including any mandatory OCTC training. The other thing we were looking at is allowing SDTCs to attend trainings given to OCTC attorneys rather than being limited to these pre-recorded training sessions. And my understanding is that OCTC is an agreement and that will happen going forward. So here you have the description, the list of all the trainings available. I'm happy to answer any questions.
Any question?
Are these available online?
I'm not sure. I don't know if that's my assumption. I'm not sure how they're accessed by the SDTCs, but my understanding is they're available to them on demand.
I mean, it might be interesting to require some sort of basic training for any attorneys or firms who have or manage trust accounts, you know, once a year or once every 3 years, something like that.
Right. That's a good idea.
Melanie Lawrence.
Just a couple things. Mark, to your question, they're not available online for the public, for example. And you know, one of the reasons is we might be talking about actual confidential investigations when we're talking about these cases. But I think that there is a project going on to have an online module for client trust accounting training for attorneys that hopefully we'll see later this year. But a couple of other things just to put it in context, especially given sort of why we're all here to begin with, is, as Robert mentioned, the Special Deputy Trial Counsel program didn't even really have an administrator until 2016. And it's probably been, I mentioned in the training session, talking about the training, that we formalized a training team really in around 2017-ish. And it's probably been maybe 2018, I would say, that we've incorporated the special deputies into that. So prior to that, there really wasn't even any formalized training for the special deputies. So we are actually doing that now. And I would absolutely be in favor of the special deputies being required to participate, whether it's in person or taking the remote trainings, at least on the kinds of trainings that we require of our investigator and attorney staff, because, you know, these kind of things, and, you know, for example, the CTA modules that we've been doing, there's no reason why they should be accepted from it. And I think it'd be really helpful for them.
Great. Thank you, Melanie. Melanie Shelby.
Thank you for that overview, Melanie. I was going to ask about that. And Robert, I appreciate sharing that you're looking at mandatory training. What's the timeline in terms of that implementation?
So I think the idea is that we would include it in their contracts for the following year. So it would be, I'm not sure when those are up for renewal, if it's individual or as a group, but we would include it in the contracts for next year.
Okay, thank you.
It's good to keep in mind that my understanding is that many of these attorneys have other, you know, they have their own practice, so they may take one case, you know, at a time. So we have to find a way that it's effective for them to do it. So if they take a training on a specific topic, they may not get a case that addresses that issue for a while. So we have to make it not overly burdensome or not a training that they won't actually use for, you know, for a while. So we're trying to look at those issues and making it a requirement of their contract.
No, that makes sense, but you also want some level of uniformity, so.
Absolutely.
Thank you.
And we did just, I think, nearly triple the hourly rate, or we doubled it. We did something significant. You all did at the last board meeting. So imposing some new training requirements is probably, now's a nice time to do that. So it sounds like if there is any recommendation that would come forth from the committee, it would simply be to support the transition to the transition to mandatory training for this group, which is already being planned. Okay.
Yeah.
All right.
Thank you.
So now we're going to move back to Richard Richard is going to give you all an overview of one other kind of model for CTA management, very different than the audit model. We really want to put it forward. I think, at some point, this would be potentially a great direction or path for us to pursue as a state. I personally am not sure we're ready to do this quite yet, but we wanted to make sure to bring it to your attention. And then he's going to transition into talking about the report itself and your final recommendations. So go ahead, Richard.
Okay, thank you, Leah. So the essential idea of a third-party managed account is simply that rather than having attorneys holding client funds, either from the client or from a defendant in a case where there's a settlement coming to their client, rather than having the attorney hold those funds, the notion is that a separate third party holds those funds. It's a concept that's familiar in real estate transactions. It's also used in a number of other kinds of transactions where you want a third party holding the money and controlling what comes in and out of that account, just for accountability and to remove any appearance of conflict of interest on any side of that transaction. So the potential advantages of this approach are that it reduces the risk because it's being held by this third party, and that also then reduces the cost of regulation, both for in this case, in legal context, for the attorney in terms of audits, reviews, et cetera, record keeping, and for the state bar or the law society or whatever it happens to be from the side of regulating, because all of that record keeping and control is in place in the third party institution. There are some claims that this also helps reduce professional indemnity insurance and possibly even client security fund type obligations on the part of individual attorneys to pay in. I have not covered any hard data about that, but it seemingly is a logical connection to this idea. And then the idea is also that it helps mitigate or reduce or even remove the problem of these little balances that persist and never get refunded to clients, which is another thing that happens in client trust accounts. The client moves, the attorneys, even in good faith, can't find their client anymore. And so you have this kind of messy bookkeeping problem and issue of where that money goes and what level of effort is reasonable to get it into the right hands. So if we can go to the next slide, there's a few variations on these. Very briefly, Utah right now is experimenting with a pilot program. It's of limited scope, so they're operating this in the context of what they call their regulatory sandbox, which just means for a limited duration of time and for a limited purpose, they allow practices to go on that would normally not be consistent with their rules. The idea being you get real world experimentation that's carefully monitored. So it allows, hopefully, the development of innovation in that space. This project is fairly limited in that what it's doing is it doesn't pertain to settlement funds. It pertains only to the billing and client legal fees and these retainers. So it's providing this third-party service in that context. And it seemed from what I could read that their business model really seemed to be about trying to reduce the cost and the overhead for people without, these are not huge cases, but they're people that just need to transact business with an attorney and need to do it in an efficient way. So that's sort of what they're experimenting with in Utah. Meanwhile, in Europe, if we go to the next slide, there's some long-standing third-party managed account solutions that have been in place in the UK, for example, where, well, this was not as long-standing. We'll get to that in a minute in France, but here they were permitted, not required, but permitted in 2019 for solicitors. And in the case of barristers, they have a third-party institution that is actually owned and operated by the Bar Council of those barristers. So and here again, it's a different variation because this pertains to not to the legal fees per se, but to all the other money coming and going around the case. So that's yet another 2 different flavors in the UK. And if we get to the last slide. In France, this has been in place since 1957, where there's essentially this third-party institution that's owned and operated by the local bars, of which there's about 180 in France. So essentially, these are go-between institutions that aren't technically banks, but they are in between the lawyers and their clients and the banks. And again, fulfilling that function of accounting for. In these cases, attorneys simply can't take their fees, for example. They have to, in a sense, provide an invoice to the third-party institution to document their services and then have that reviewed and dispersed. So there's a bit of client security in that there's someone overseeing the business related to their account who's not in a conflicted position. So those are the various flavors of third-party managed accounts. I did not include there another one that's being discussed in certain places, which is the use of cryptocurrencies, which take advantage of blockchain technology to create these ledgers and control the money, but that's pretty far out, I think, in terms of regulatory acceptance. So for that reason, it wasn't included here, although serious papers have been written about this in the legal context.
And if we ever go in this direction, essentially requiring independent escrow accounts to be established to hold all client funds, whether to pay fees or to receive settlement funds, it would obviate the need for a lot of things. There wouldn't need to be registration. There wouldn't need to be auditing. There wouldn't need to be accounting done. It's an entirely different model. And I think it is very attractive. I think Richard and I view it as sort of a bridge too far at this time. But I did want to bring it to your attention. And I think the Utah Sandbox project is interesting. As you all know, the board will be considering the sandbox proposal to establish a sandbox proposal in California next year. These are the types of projects that we might be able to test out under our own sandbox in the near future.
I should also mention before we go on that these third-party managed accounts, there is also in California state government an audit, oversight program for exactly these kinds of escrow, non-real estate escrow accounts. They're used in a variety of transactions, film investments, surrogacy instances where a third party holds the funds on behalf of both sides of that. So sometimes there's single transactions, sometimes broader than that, but the Department of Financial Protection and Innovation has a staff of 10 compliance and auditors who conduct a number of audits annually of these accounts. The accounts also report through the use of independent certified public accountants. So they run a very robust program of oversight. As you can imagine, there are many of these accounts in and institutions in California that includes film rights, all kinds of things. So it is currently being done as a form of regulation that's not the Department of Real Estate and that's not the regulatory apparatus over banks, but it's a separate domain, if you will, that they are responsible for.
That's great. Great information, folks. You might have mentioned this, but I think I'm right in understanding. Short of making it mandatory for all client trust accounts or for all attorneys to use this model, it's not even allowed under current, right? That attorneys could do this today.
No, I mean, Randy's not here. Melanie, I looked to you, but I don't think so because there are attorneys required to manage their client trust account, right? They can't give that responsibility to somebody else.
Right. I mean, it's a non-delegable responsibility, but so ultimately what happens in the account is their responsibility.
So one thing to consider as we discuss this going forward, I agree that it's probably not something to mandate today, but we could see making just permissive at some point, and see how that works out. Okay. Any other discussion or questions? All right. Thank you very much.
All right, so now we go on to the outline for the report. I think most of this is fairly self-explanatory. What we're trying to do here is just capture all of the issues and recommendations that we've been discussing, the committee's been discussing over the past couple of months. So, we began with what's the charge. To that original charge from the board's resolution, a number of issues were added that the committee has been discussing, several of which we've discussed today. So we'll take note of all those in the report. And then we go on from there to the set of recommendations that we have been discussing. In terms of client trust accounts, those just to repeat them one more time is the annual registration, annual certification, annual self-assessment, compliance reviews by outside CPAs, by attorneys who have been selected through a combination of random selection as well as risk-based selection, and then the risk review and follow-up by the state bar, which ranges from closing the file in the case that there's no deficiencies, and all the way up to formal discipline in the worst case, and in between having graduated oversight measures, including correction plans and closer supervision. So those are the recommendations that we have discussed, which we will be capturing. And then what we also spoke about, if we can go to the next slide, is the need to phase this in. And so at the end of our October 12th meeting, Leah summarized a couple of phases, and I got one piece wrong here, which is that phase 3, self-assessment, originally we had put that in phase 2 as a way to ramp it up. So we begin with annual registration and certification of compliance. We move on to the CLE, mandatory CLE, and the client and public education pieces that help people understand what their rights are in this context. And then self-assessment, which is essentially a tool for attorneys to assess their practices in more detail. And it includes some of the issues that we've talked about in the earlier discussion. For example, affirming that for each account that there are monthly reconciliations that have been done. A number of these things, those simple record keeping things, as Melanie and others have mentioned in the discussion, just those are immediate flags, if you will, that often lead to revealing more serious problems. So while the questions may seem simple or just descriptive, they are in fact significant, and they do form an important part of the data that we begin to compile to develop the risk profiles going forward. So the idea is to phase this in so that in that last phase, we have the compliance reviews on selected attorneys and these follow-up actions, including audits. And partly this also, it allows the state bar to put in place the pieces of this, of these programs. And that includes things like, if we could go on to the next slide, skip over this for just a second. Implementation requirements. Randy did a great job of sketching out a possible path forward with respect to how the rules of court and the rules of professional conduct and statutes, how a new rule of court could be created that would essentially contain the language that the statute and other rules would point to, outlining what the state bar is putting in place and what the duties and responsibilities of licensed attorneys in California are with respect to client trust accounts. So that there's a table that we will present in the report of those things. By each recommendation, what would need to change and how for each of those, so that can be clearly seen. And we will also make mention of issues that the committee has discussed, but about which it's not making specific recommendations, like third-party managed accounts. The resources piece, here we want to at least sketch out some of the implications of putting such a program in place. For example, we have some information from other jurisdictions as to the staffing levels that are associated with the level of review and audit that they do. That provides a sense of the scale of the operation we're talking about. There's also, we want to be able to describe, what the kinds of IT investments that allow not just for the efficiency of this from both the attorney side and the state bar side, but also allow the data to be collected and maintained in a way that allows the other thing we've talked about, which is patterns of behavior, patterns of risk factors, to be analyzed by analytical staff at State Bar and used to focus the effort in the years going forward. So that's a significant investment in resources that also just needs to be noted. So those are the main components there, and then appendices that reference documents that the committee has reviewed, so that those foundational pieces can be also accompany the report. In addition, for the matters that we've discussed today, that attorney conduct and training, we will mention those and work with Melanie and Randy to get the right language in there as to the wishes of the committee in those areas.
Can we go back a slide, Louisa? Because I do think, Richard, we should talk about the malpractice insurance piece.
Yeah, so I was hoping you would. Because this is another related issue which has come up. There was a malpractice, there was a working group on this that prepared a report, and it's clearly related to, the question has come up in discussion. Is this part of the solution that needs to be re-examined in the context of client trust accounts with respect to making it mandatory, with respect to what coverage pertains in that, and what reporting requirements are? Because as we noted, currently, without this insurance, it relies on attorney self-reporting claims of malpractice with respect to client trust accounts, as opposed to an insurance carrier reporting those to the state bar. Did you want to add more to that, Leah?
No, just to say we have it kind of, I think this committee didn't settle on this question at the last meeting. There's multiple options. You could recommend, yes, let's make malpractice insurance mandatory. That could be part of your recommendation. I think there was some discussion of studying the issue further. The issue has been studied quite a bit. So if we're gonna recommend further study, I think we need to get clarity around exactly what we're studying and why. So I see, Mark, maybe you have a suggestion on how to move this one forward, Mark.
Well, I don't know about a suggestion on malpractice insurance. I'm not sure the carriers would cover it, but I think, as I raised before, I was inquiring of some other firms, and there was one firm where an institutional client, a bank, required them to have certain bond requirements. And there's what they called to me a fidelity bond that insured the trust account so that they didn't, if they made a mistake or if somebody ran off with trust account money, this bond would pay for it. That's sort of along the lines of malpractice insurance, and I didn't see anywhere in there where, Richard, you looked at that possible issue.
I have not looked at bonds, no.
That seems like a good thing to look into, because we might as well understand the whole landscape.
And we probably won't be able to do that for next week when we have to finalize this report, but we can indicate that that's an outstanding issue and that we need to look into it subsequently. But on this question of malpractice insurance itself, is that, just curious where the committee members are.
I don't know if an insurance carrier would cover an intentional tort, so to speak, which is what this is. If the attorney is either commingling or taking client money. It's one thing if you're negligent, they will cover negligence. I don't know if they would cover an intentional act.
No, I think we do know that they don't cover intentional acts. Ruben, Melanie, Jose, I think we lost Highland.
Yeah,
But, I mean, I guess the question that raises for me then is, I mean, does the board want to revisit the mandatory malpractice insurance question? I mean, as I think most of us know, there was the better part of a 2-year effort that went into the report that went to the legislature in 2018 in the context of the issues that this committee is dealing with. If we're talking about tortious activity that's not going to be covered by malpractice insurance, then I don't know that this is the proper forum for that question.
yeah, anyone else? I think I would agree that given that a lot of our focus has been on client trust accounts, if malpractice insurance wouldn't protect a client from bad acts of an attorney in terms of stealing, misappropriating, or jeopardizing their client trust account funds, then that sounds like the malpractice insurance is obviously protecting against something else, some other risks that could provide protection, that it could therefore provide protection to members of the public. So we should probably revisit that. But in terms of this discussion, maybe we should say that we will do some further looking into what would protect client trust account funds, and if those, and we would, as you just said, Leah, pursue some further investigation to see what bonds would do. Anyone else? Melanie Shelby.
I think Mark Broughton was waiting a little longer than I was.
No, I just forgot to unclick my hand.
Okay, perfect. I guess my question, not being engaged in the previous conversation around malpractice, is what's the downside? That's my first question. And then my second one is, if it weren't addressed here in the context of what we've been dealing with, where would it be addressed? And then my third piece is this still an issue for the legislature? That probably should have been my first question. And then that then follows the alignment of the other two. So is it still an issue for the legislature? What's the downside? And if it isn't addressed here, then where would it be addressed?
So I would say, I don't know if it's still an issue. We were directed to do that study by Senate, in the fee bill that was authored by the Senate Judiciary Committee. We did the study. It didn't recommend making it mandatory, and the legislature didn't pick it up and make it mandatory anyway. I have a sense that the state bar making malpractice insurance mandatory would be welcome, but the uproar that would result from the attorney community would not be welcome. But as long as it was purely directed at us, I think the end result of having mandatory malpractice insurance would be perceived as a positive. That's my political sense. The downside is this is really an unpopular concept for the approximately 30%, what we estimate to be 30% of attorneys that are uninsured. And there are lots of arguments about it. Some say that it will disproportionately negatively impact attorneys of color who have lower volume businesses as it is, and then you're imposing a new cost. Others say it will result in increased cost to the consumer because the attorneys will have to pass along the cost of the malpractice insurance to their consumer. So those are some of the arguments that we've heard. They were ultimately persuasive with the working group. And that's sort of the downside, Melanie, is, we would hear that again. I struggle with this one because I think it is absolutely the right public policy. It's kind of a no-brainer in a sense. But I don't know when the right time is, frankly. It wasn't the right time before. Right now, we might have a policy window because of the Girardi issues, and he was not insured. But we also have, a lot going on right now, like our paraprofessional program recommendations, which are generating some concern. And next year it will be the regulatory sandbox. So
that's helpful. Thank you. I guess my follow-up thought would be, is this a place to kind of quietly talk to COAF leadership, right? Since they focus, their focus is the Council on Access and Fairness. And then is there an opportunity to kind of raise this silently with some of the bar associations of color to see if it's an issue that they've been addressing and dealing with in their constituencies as well? And then last but not least, I would say the legislative caucuses of color, in terms of raising this as well, maybe with some key staff to see if it's anything that resonates. That way you've got 3 different perspectives from 3 different constituencies that are focused on communities of color and underrepresented communities.
that's a good idea, to kind of keep it moving by doing more information gathering, really focusing on one of the, I think, most compelling arguments against making it mandatory.
So in that regard, it would probably be helpful to pull out the working group's report that went to the legislature, and maybe, I'm sure there's an executive summary of it, and provide it to the groups that Melanie just mentioned as background or in preparation for some of those conversations.
Yeah, absolutely. So I think, Richard, we can come up with some language in the report that reflects this discussion. I think that's a good concrete recommendation.
Okay, will do.
Sounds good.
And I think that's it.
Okay, I think that wraps up all the items on our open agenda.
Yeah, so we do have a brief closed session agenda, and I would just say for our next meeting, the only item we will have is the draft report on November the 5th, which we will do our best to get to you in advance, in time for you to actually read it before the 5th. So,
Okay,
all right.
sounds good. Then why don't I move on and announce that we'll be going into closed session for a discussion regarding audit of closed Office of Chief Trial Counsel files pursuant to Government Code Section 11-126A1 and 11-126C2. The committee will be going into closed session to discuss the matter I just mentioned. We will be leaving this Zoom call, and we will be returning to this Zoom after the completion of our closed session item, and we will be making a report if there is anything to report out from our closed session. With that, I believe, Louisa, you've probably emailed to us a closed session link.
Yes, should have received it just a couple of seconds ago.
Okay, great. Folks could go to that link. We'll see you back here after. Thank you.
You're muted.
Jose,
You're muted.
Thank you very much, folks. Welcome back, everyone. Welcome back to the meeting on the Committee on Special Discipline Case Audit. The committee just met in closed session for a discussion regarding audit of closed Office of Chief Trial Counsel files. Pursuant to Government Code, Section 11-126A1 and 11-126C2. The committee has nothing to report out of that closed session. With that, we've completed all the matters on our committee agenda today, and therefore this meeting is adjourned. Thank you, everyone.
thank you.